Hello, I'm Andrew, a recent NCA graduate, and welcome back to my channel. This is the third video in my latest vlog series, How to Ace the NCA, a guide to becoming an internationally trained lawyer. So in the previous two videos, we have discussed the application process and the exam process and how you can best prepare. So in this video, we will be covering the foundations of Canadian law exam. We will cover the key concepts and principles that will provide you with a better understanding of Canada's legal system and the role of law in Canadian society. Please note that as a general rule for this vlog series, I will try to keep the length of the videos to a minimum and only cover the core concepts, as both of our time is valuable and it is near impossible to condense an entire syllabus into one single video. So having said that, let's get into it. So during the NCA process, there will be some overlap between different exams, as each may explore the same area of law from a different angle. So it is vital that you study each syllabus individually and prepare your notes solely for that exam. Please do not mix your note bundles, as this will cause confusion and cause you to lose focus in the exam. For the purpose of this video, I will not be covering each concept in great detail, as I will create future videos and podcasts that will specifically focus on a topic or a case. So firstly, it is vital that you understand the difference between the federal government of Canada and the provincial governments of Canada. So the federal government of Canada is responsible for making laws and policies that affect the entire country, whereas the provincial government is responsible for making laws and policies that affect only that province or territory. In Canada, the concept of paramountcy refers to the idea that in situations where there is conflict between the federal and provincial laws, the federal law will always take precedence or be considered superior, rendering the provincial law invalid to the extent of the conflict. So it's very important to note that the superior law, which is the federal law, will render the provincial law invalid to the extent of the conflict. So not in the entirety, unless the conflict is in the entirety. So the second major concept that you will need to understand is the difference between the Constitution Act of 1867 and the Constitution Act of 1982. So the Constitution Act of 1867, also known as the British North America Act, was the British law that established Canadian federal system of government and set out the powers of the federal and provincial governments. It created the framework for how Canada would be governed, including the division of powers between the federal and provincial governments, the structure of parliament, and the role of the monarchy in Canada. So the Constitution Act of 1982 is a Canadian law that passed by the Canadian Parliament with the approval of the British Parliament. The Constitution Act of 1982 contains several important provisions, including the Charter of Rights and Freedoms. which protects fundamental rights and freedoms of Canadians, such as freedom of speech, equality before the law, and the right to vote. It also includes the procedures for amending the Constitution. One of the most significant differences between the two acts is that the Constitution Act 1982 gave Canada full control over its constitution, ending the need for approval from the British Parliament. So prior to that, the Canadian government required the approval of the British Parliament. You will cover the Canadian Charter of Rights and Freedoms in greater detail during the constitutional law exam. So for now, all you need to know is that both acts are important parts of Canada's constitution and have helped shape Canada into the country it is today. So the third major concept that you must understand is bijuralism. So what is bijuralism? Well, bijuralism is the principle that Canada's legal system is based on two distinct legal traditions: the common law, the English common law, and civil law, which reflects the two official languages of Canada, English and French. This principle ensures that Canadians can access legal services in the language of their choice, while also respecting the legal traditions of both language groups. So that brings us to the last major concept that you will encounter throughout the entire NCA exam, and especially in the Foundations of Canadian Law exam 2, and that's our Aboriginal rights. As an English law graduate myself, this area of law is completely new to me, or was completely new to me, and is something that I am deeply fascinated by, and I'm sure you will too. I would urge anyone watching this to study the history of Canada and the impact of colonialism on its history. So for the purpose of the exams, please do not label Aboriginal and First Nation peoples as Indians, unless you are specifically referring to the Indian Act. So Section 91, subsection 24 of the Constitution Act 1867, or the British North America Act, gives the Canadian federal government the exclusive power to make laws related to Indians and lands reserved for the Indians. This means that the federal government has the authority to pass laws regarding the legal status and treatment of Indigenous peoples, and to regulate the use and management of Indigenous lands. In comparison with Section 35 of the Constitution Act 1982, which was added to the Constitution after Canada gained full independence from the United Kingdom, recognises and affirms the existing Aboriginal and treaty rights of Indigenous peoples in Canada. This means that Indigenous peoples have certain rights that are protected by the Constitution, including the right to hunt, fish, and gather on traditional lands, the right to self-government, and the right to be consulted on any decisions that may affect their lands, resources, or culture, also known as the duty to consult by the Crown. So the burden is on the Crown to consult with Aboriginal groups where their rights are directly affected. So a question on Aboriginal law is pretty much guaranteed to pop up on the Foundations of Canadian Law exam. So this is an area I would strongly suggest that you study, and you also remember the importance of both sections 91 subsection 24 of the Constitution Act 1867 and section 35 of the Constitution Act 1982 when preparing your answers, as these will be the foundation of your answers. So that brings us to the end of the video. I hope that you enjoyed this one. I know it's a little bit longer than the previous ones, but going forward, I hope to keep to a minimal. If you have any further questions on the concepts covered, then please feel free to drop a comment below or give me a direct message on my socials, and I will do my best to answer. In the next video, we will be looking at the constitutional law syllabus, with a particular focus on the Canadian Charter of Rights and Freedoms. So thank you for watching, and good luck with the Foundations of Canadian Law exam preparation, and I hope to see you in the next one.